Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. Words matter in arbitration agreements, particularly now in the age of AI, where the smallest turn of phrase or omitted clause can leave an otherwise sound agreement vulnerable in court. We saw an example of this recently when the Sixth Circuit denied an employer's motion to compel arbitration, broadly reading and applying an exclusion clause in the employee's arbitration agreement. The deciding factor for the court? One word: involving. We asked Epstein, Becker, Green's Jonathan Brenner how poor agreement construction can open the door to this kind of scrutiny.
Not paying careful attention, for example, to the way an agreement reads regarding the availability of discovery, the neutrality of the arbitration process, confidentiality of the proceedings, and mutuality and scope of the entire agreement can lead to adverse outcomes for enforceability of those agreements, or at least at a minimum, provide incentive or ammunition to challenges to those agreements.
Jonathan, what is your advice when clients use AI to assist in drafting arbitration agreements?
Anything done by artificial intelligence in terms of arbitration agreement preparation or drafting should be checked. Input from counsel should be obtained. Employers should keep in mind that AI might pick up what may currently be out there by way of judicial guidance or existing law, but it may not pick up what arguments could be made or might be currently made in pending cases right now that might be very relevant and meaningful for an arbitration agreement being prepared today.
Keeping up with recent developments and catching nuances in word choice are areas where AI can be inaccurate. It's also best practice to keep a human in the loop whenever decisions are being made. With us now is Victoria Sloan Lynn. Victoria, how should employers approach decision-making in arbitration agreements?
Make sure you ask yourself, what is the primary benefit to my company with respect to an arbitration program? It may be confidentiality, but there may be other factors that are important to you, such as cost. Also, be sure to familiarize yourself with the rules of the forum you've chosen for your arbitration, particularly when you've incorporated those rules by reference into your arbitration agreement. There may be terms in there that you want to alter in the agreement itself. There is still a lot of flexibility that can be built into an arbitration program, but make sure that the choices you make are right for your company. Also, be sure to read across arbitration provisions if you have them in different agreements to make sure they're consistent.
Thanks, Victoria and Jonathan. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.